All right, we are going to go ahead and get started. I want to thank you all for joining us on today. We do have a special guest and we will record. It's already showing recording, so that's a blessing. I'm going to go ahead and read Dr. Shima's bio so that you all can have a little bit of knowledge on where she comes from. So it says Dr. Shema T. Freeman, Esquire, founder and managing attorney. Dr. Shema T. Freeman is the founder and managing attorney of Urithi Law, a law firm focused on estate planning, probate, wealth preservation, and real estate related legal services. Licensed in both Texas and Florida, she helps individuals, families, entrepreneurs, and real estate investors build, protect, and transfer generations. During the legal profession, Dr. Freeman earned a BS, MS, and PhD in materials science and engineering from the University of Florida and later earned her Juris Doctor from George Washington University Law School. Her diverse professional background includes service as a patent examiner with the United States Patent and Trademark Office, experience in intellectual property law, and extensive involvement in real estate investing and development. Inspired by her family's personal experience navigating estate administration, Dr. Freeman founded Urithi Law to provide families with practical legal guidance during some of life's most important transitions. The firm's name, Urithi, means inheritance in Swahili and reflects its mission to help clients preserve wealth, honor family legacy, and avoid unnecessary conflict. What distinguishes Dr. Freeman's practice is her ability to integrate legal counsel with real estate and business strategy. As a licensed real estate professional and investor, she understands the unique challenges faced by property owners, entrepreneurs, and families whose wealth is tied to real estate. Her approach combines legal planning, education, and strategic guidance to help clients build wealth, secure their legacy, and strengthen family connections for future generations. Dr. Freeman is a member of the State Bar of Texas, the Florida Bar, and the San Antonio Black Lawyers Association. When she's away from the office, Dr. Freeman enjoys cheering on her beloved Florida Gators and proudly supports the orange and blue every chance she gets. She also enjoys spending time on the golf course. All right. Though she'll
Mhm.
her golf game is still a work in progress. Most importantly, she treasures time spent with family, close friends like myself, and her beloved fur baby. These experiences reinforce the values that guide both her life and her practice, building meaningful relationships, creating opportunities for future generations, and recognizing that true wealth is measured not only by what we accumulate, but by the people we impact and the legacy we leave behind. Build wealth, secure legacy, and strengthen family. That is what she stands on. So I would like to go ahead and give Dr. Freeman the floor and she will start her presentation. Thank you so
Thank
much.
you.
Yes, ma'am.
Thank you. I wrote that. Wow. I sound good. All of that is true. And so I'm going to go ahead and share my screen with you guys and get this started. Move the people out the way. And this will be very conversational. So if you guys have questions along the way, feel free to put them in chat or, just go ahead and open your mics and let me know. But Tomekia, thank you for having me. This is a new presentation. I've been doing an iteration of this one, but for this one, I really want to share my heart for why I do what I do and what happens when you don't have a plan. So I won't spend too much time on the introducing myself part, but I do want to share a couple things that weren't in the bio. Um, some of you know, some of you don't. Like those that know me and have spent time with me know that I really got into this because in grad school, my mom had a heart attack and a heart transplant. And the Lord blessed us with 19 years after her transplant. Um, but she did pass a few years ago. And you've heard in the bio all of the education that I have and some of the accolades. And even in that, we didn't get everything right. So, what, 4 years later, I'm still dealing with some stuff from her estate. And I figure if someone with all of my legal knowledge, I took one estates class in law school, can't get through this unscathed, then how do most people get through this? And that's really where my passion comes from. The firm, I am a believer, so the firm is built on two key verses for us. Proverbs 13:22, a good man leaves an inheritance for his children's children. And Proverbs 20:21, inheritance gained too quickly or without wisdom will ultimately not be blessed. Um, so that's why what I do is build, protect, transfer, and strengthen families. Because at the end of all this, even though you have the stuff to pass down, if the family is not whole, and then the impact is fractured and none of it really matters. So let's get started. By the time we get done in this, I'm gonna try and speed through because I think you gave me 30 minutes, right? So we'll kind of speed through it. But at the end of all this, you'll be able to explain what estate planning is. Hopefully, you'll understand a little bit about probate. Um, you'll be able to protect your property. You'll recognize what risk your family may be at. Hopefully, you'll be able to work through what kind of plan you actually need, and then at the very end of it, you'll be ready to take some action today. So let's start. What is estate planning? It's really about control during your life, control if you become incapacitated, and then ultimately control when you are no longer here with us on this earth. So during your life, an estate plan will manage your assets, it'll protect your property, and it'll show your wishes are. It allows you to instruct how your property will go during your lifetime. If you are ever to become incapacitated, and I think most people underestimate that this is a risk, um, the chances of you getting into an accident or succumbing to dementia are much higher and more imminent than death. So if you were to become incapacitated, then the estate planning documents that I'll talk about here in a second allow your trusted people in your life to manage your finances, your health care, and all of your other assets. And then I think most people understand that after death, your estate plan directs where your assets will go and who they will go to. So there are four key documents that we deal with in estate planning. The will, I think most people are familiar with that. It names your beneficiaries. You have an executor that manages it for you. You'll allow to name your guardians of your children in that way. The trust is the next key document that we deal with. I like to think of trust as like a a bundle or a basket where all your assets just get put into this basket. Um, a key differentiator between a will and a trust is that a trust will bypass probate, and I'll talk a little bit more about that in the next slide. The next key documents are your power of attorneys. You have both a financial and a medical power of attorney. And again, that allows someone that you trust to manage your finances and then also your healthcare decisions. And then the last document is a healthcare directive. And this, you may have also heard it called a living will. It gives instructions on how you like to be cared for if you become incapacitated. So whether or not you want to be on a respirator, whether or not you want to go to a rehab facility or go back home. So all those key decisions are held in that healthcare directive. So some key differences between a will and a trust. Um, the will, it goes through court, right? So it's a public all the things in your will become public. It could take anywhere from months to years. On average, I think it's 6 to 18 months. So a year, 6 months to a year and a half, as opposed to a trust where you avoid probate completely. Everything's private. Most of what I do in trust is done in my office, or actually, a lot of it doesn't need to be done in my office. It's just a matter of, you know, the trustee picking up a phone call and calling me, and then I handle the retitling, and you guys just sign a bunch of things. And most of the time, it takes days, maybe some weeks, but certainly not as long as a will and probate. Again, I said everything with the will is public record. In a trust, it's all private. A will does not help you if you become incapacitated. So if you were in an accident, your family members still wouldn't have access to your bank accounts. They wouldn't be able to make medical decisions for you. And a trust allows you to put all those things in place. I will talk about how we supplement the will with those other medical directives to allow some of that to take place. But the trust is a standalone thing that allows for incapacitated folks to still be able to manage your properties. The one thing that a will does that a trust cannot is it actually names the guardians of your children. The trust will handle the money, so they actually work together. Um, there are some things that we can do in a will as far as like having a trust created when you pass. Uh, that is that you can still direct the money that way. But it does take a little bit longer to go through because you do still have to deal with probate. Uh, the will is generally a less expensive product than what a trust will be. And I'll go through some of that at the end as well. And again, we talked about how if you go through probate, it's going to be months. If you have a trust set up, it's probably going to be days and weeks. And I mentioned this before that estate planning is not just about death. We've talked about these documents, but most people don't understand that you becoming incapacitated is a much larger risk of you than you dying. Because if you succumb to an accident, or if you are injured in an accident and can't work, um, and don't have access to managing your money in your household, you need someone that you trust to do that for you. So I won't go into more on these details, but understand that it's really that three parts to estate planning: during life, during incapacitation, and then after death. Now, most people know or will hear probate, and it's really broader than that. It's called estate administration. And regardless if you have a will or a trust, everybody's estate will go through some sort of administration. What most people know is probate is really step one. It's the estate opening, and that's when you go before the probate court and you get the will validated, and that kind of begins the process. Step two is the asset and liability discovery. So it's a matter of searching through the deceased records, finding out all the things that they own and all the people that they owe. Um, Now, two, three, and four kind of go together, really, because during when you discover that, you're also managing that. So you're paying on things as they come up. Um, you're keeping track of what creditors come forward and all that. And then once you've kind of gotten through the inventory and the court process, that's when you start to do your distributions. Remember, if we're going to talk about here in the next slide about how we make sure that most of our assets are not probatable, but all your creditors will get paid before any heir will get paid. So our goal is to make sure that we have as many non-probatable assets as possible. So we don't want the court to know what money you have, and we definitely don't want them to decide who it's going to if it's creditors. So yeah, this is where we talk about what are probate versus non-probate assets. So you guys can take a look at your own assets and decide, what category these fits into. Most probate assets, any real estate named in your own name alone, bank accounts, investment accounts that don't have a beneficiary designation on them, vehicles, personal property, and any business interest owned individually. Non-probate assets, life insurance. A lot of people don't know that that is not a probate asset. So that goes to whoever is named the beneficiary. That has its pros and cons. We'll get into that a little later too. Your IRAs or 401ks, those are not probatable. They also have a beneficiary designation on it. Bank accounts with a pay on death or a transfer on death designation are also not probatable. Those will go to whoever is named as the beneficiary. Joint real estate, as long as it's titled properly, like it has to have that survivorship language on the deed. And then any assets in your revocable living trust. None of those are probatable. So before we jump into what probate is or what that procedure looks like, let's talk about some of the players. You have your executor. That's the person that is going to hire the attorney. That's the person in charge. They won't actually get named the executor until we go to court. So the judge will name the executor, but as long as that person is named in the will, they will be appointed as your executor. Then you have your estate attorney. That's me. And they pretty much do all the hard stuff, right? So they'll help you with the filings, they'll help you with inventories, and just that legal process. If you have a trust, you also have a trustee. A lot of times, your personal representative and your trustee are the same person, and so they're managing all the assets in your trust as well. And then finally, you'll hear beneficiaries. Sometimes you'll call them heirs. If they are in a will, they are a beneficiary. If there is no will, then they are an heir at law. So, as I've said before, probate is just a court supervised process of dealing with your estate. The court will determine whether or not the will is valid. So that means if the formalities are met, right? Does it have the right signatures? Was it witnessed properly? Was it notarized property? All that. Then they will appoint your executor, and then the executor then will have the job of like summoning all the assets and the liabilities. We will put out notices, and the creditors will, at that point, will have a chance to chime in and see to talk about who that deceased person owes. And then finally, once all that's settled, all the rest of the assets are distributed to the beneficiaries and or heirs. So now I'm going to go into a couple of examples because I like to put some real worldness into my presentations, right? So these first three are probably three of my favorite artists. I'm kind of old school. My grandmother raised me, so I listen to her music, right? So Aretha Franklin, estimated estate of $80 million. She died in 2018 with no will, no trust, no plan at all they found were some handwritten notes under couches, and it took them a while to determine whether or not that was supposed to be a will or not. So her four sons ended up in this long legal battle. Her estate, or her home in particular, was pretty much lost to creditors. I think the sons got some funds from that, but again, that is the risk we take when we don't have a plan in place, right? The state was tied up in the Michigan court, I believe, until 2022. But this is just an example. And like I said, probate is public record. So if you really wanted to, you get onto the Michigan public record site and try and figure out what all she owned and who she owed. This is another one that is absolutely crazy to me, that Prince had no will in place, right? So his estimated estate was $156 million.
Mm-hmm.
100 million of that went to the IRS and to the attorneys. So there are a couple ways that the attorneys get paid on these sorts of things. Like it could be a percentage of the estate depending on how much the estate is worth. So, and that percentage can be anywhere from 3% to 10%, sometimes 13%. So imagine the attorney taking 10% of $156 million. I'm not mad at it as the attorney, but you know, that's money that could have gone to the family, right? There were 30 plus claimants to his estate. A lot of them were strangers or distant cousins that he never really dealt with. And the part that really eats at my soul is that his studio, Paisley Park, was sold to a company. It's not managed by the estate any longer, so they're not getting any of the residuals from his catalog. They have now turned Paisley Park into a museum, but the family is not benefiting financially from that at all. And again, a will and a trust plan could have easily set him up, and the family could be living off of all that, all the residuals from his catalog and from the studio at this point, and they have nothing. So his legacy is pretty much wiped out at this point, other than what we all know and love about his music. This one hurts a lot too. Chadwick Boseman, again, no will in place. He was young when he died. He was younger than I am right now, 43. He had only been married for a year. And the thing that it eats me about this is that he knew his diagnosis and had time to put something in place. He had 4 years of dealing with his cancer diagnosis, and just for whatever reason, setting his family up for the future was not a priority. So the lesson here is not even the estimated net worth. It's really that you don't want some sort of terminal diagnosis to be the reason that you are planning, because this is something that you can do now, and it's not a one and done thing. An estate plan is something that we revisit every couple of years to see what's changed. And so now is the time to really start to think about where this is going. Okay. A lot of this we've already talked about. If there's no plan, then a judge decides where your children or who raises your children. Your assets, your bank accounts are frozen. A lot of times you have a lot of fractured family relationships. Your home, which is normally your largest asset, could be forced to sell to pay for your debts. Again, it's a public process when you're dealing with a probate, and then your wishes and your both your financial and medical wishes are decided by the state. So it's a very impersonal thing. Talked about this before. The reason you need a will at the very minimum, if you have children, if you're a parent in here and you have minor children, you need a will, because that is the only way that you can name a guardian for your children, be it temporary, be it permanent. If you don't, there is a good chance that your children will end up, at least temporarily, in the state's care, because it takes some time for the family members to petition the court and get that guardianship appointed. And also, it's a very expensive thing. I am just now venturing into this world of guardianship. I mostly work with adult guardianship, but my minimum that I'm seeing here is $5,000-6,000 as far as just the attorney fees on that. So it's probably upwards of $6,000 or $7,000, including court costs and whatnot. So it can be a very and it's not a quick process. It can take up to 6 months to work that out in a court. So if you have minor kids, we need to talk immediately. One last example from a celebrity. I think most people know the situation with Whitney Houston and Bobby Christina Brown. So again, Whitney Houston had no plan in place, and when she passed, Bobby Christina inherited her entire estate. She was 19 years old. We know what the result of that was, right? Bobby Christina had some other things going on with the addiction and whatnot, but she passed away at 22. And it baffles me that a simple trust and a provision in her trust, we call it a spendthrift provision, that allows money to come out slowly. It protects the beneficiary from creditors, and it allows for them to really mature and learn how to steward the money that's coming to them. So just another example of what can go wrong if you don't have a plan. I'll get into how some of these families can torn apart. One in particular is the blended family situation. This one is coming to me a lot more. There are kind of two ways that this can go wrong, right? I have one case where the husband remarried after his first wife passed. He named his son as the beneficiary in the will, but the wife, his current wife, inherited everything because he never actually updated the will. So in the will, it just says my current wife. So while the son is managing all the assets, he and his sister will get nothing at the end of it because everything goes to his current wife. And then we have the opposite that often happens too, in that the children don't acknowledge the second wife, right? And so I have a situation where there are 4 siblings. They're actually trying to kick their stepmother out of the house that she's living in. It's her homestead, so they can't do that. She has a state mandated life, a state that she can stay there until she dies. But yeah, so it can go either way. Either the second family is left out or the first family is left out. So we need to make sure that you have these documents in place to protect everybody in that situation. And then a special note for my real estate investors, your properties are your family's biggest risk. If they are in your personal name, don't do that. They could also be forced to sell to take care of debts. This is when you're most vulnerable to lawsuits from tenants or vendors or contractors. So your liability exposure goes up. So if they're in your personal name, then get them in an LLC, get them in a holding company, do some things to protect you, right? And the other thing too is if you're dealing with 1031 exchanges, that timing can be thrown off if you don't have somebody there that can manage it for you. This one's also for my parents. If you have an adult child, meaning if your child is 18-year-old or older, you no longer have any legal authority over anything that they have. Their medical decisions, their financial decisions, even an emergency, right? They're legally an adult by the state, so you can't make medical decisions from there if they get into an accident. Their bank accounts are frozen if they get into an accident. If they are on a study abroad and have an emergency, again, you don't have a way to speak for them unless you have the documents here that we've talked about before, financial and medical POA, and those directives in place. So we're in that graduation season still, right? And going off to college. So if you have an adult child, whether or not they just graduated or graduated a few years ago, get these documents in place because if something happens to it, like you can't even call their school, their registrar, um, and pay their tuition bills legally. I'm sure most people do because it's all online these days. But if you were to call, the registrar would be like, we can't give you any information on this child. So definitely, seek some guidance on that as well. What a good plan will do for your family, gives you the protection that we've talked about before. While a trust doesn't necessarily protect the trustee, it can protect your beneficiaries, and it can do some things with blended families, like I said before, to make sure everybody is treated fairly, or what you as the trustee would be considered fairly. It takes care of your children. It's a private process with the trust as opposed to a probate. Again, with the trust assets, it happens very quickly. I didn't talk too much about the tax benefits of it. I don't think many of us are at that 12 million, $13 million federal tax threshold quite yet. If you are, definitely call me because there's definitely some things we want to talk about to make sure that you're protected from that tax burden. But ultimately, having an estate plan in place gives you, your family, a lot of peace. You know exactly how to move forward, whether you're incapacitated or after you pass. So these are some of the myths that I get, or I guess objections I have to that people tell me about estate planning. I'm too young. There's no such thing as too young. I've talked about as soon as you turn 18, you need the bare minimum in place. Chadwick Boseman was 43. Prince was 57. Accidents don't check your age. They just happen. I don't have enough assets. Again, if you have a child, a car, a bank account, even a Facebook account, because Facebook won't let you go into their account, somebody else's account, once they're deceased. Like you need to have some sort of way of accounting for your assets, regardless of how much you think you have. My family will figure it out. I get this one a lot. This is probably the number one objection I get. I won't be here. I'll let them figure it out. That, in my opinion, is what fractures a lot of families, right? You have grief plus money and no instruction as to what to do with your things, and that just will lead to conflict. I've seen it in my own family where my grandmother's brother and sister argued for 3 months over a $500 car. This car, it was basically scrap, and she wanted to go to one person. It was my grandmother's wishes for it to go to my uncle Joe, and it was not a fun time dealing with that. A will is enough. It can be. It can be enough, but understand that even a will would go through probate. And that, again, it's a public process. I did mine online. I'm covered. I personally don't have a ton of problems with the online will and trust community. but I will just say make sure that it's properly executed. That's number one problem. Number one issue I see is that it doesn't have two witnesses. Most states require two witnesses, and that those witnesses will sign in front of a notary. So I will caution you on that way. They are a lot of times more cost effective than going to an attorney. So I understand it, but just verify that you are following the validity instructions and also the funding instructions. So how we help at Urithi, y'all. The first call is free. It's 30 minutes. I kind of gauge what kind of assets you have, what you are trying to do. And then if we decide that mutually that we want to work together, we go into the design meeting. Now the design meeting, there is a cost to it. It's $275. It's basically you're paying for an hour of my time. But the meeting itself is 2 hours. And before that, I will send you a packet of information that will allow you to fill out all of your assets, your liabilities, who you think you will want to give things to. So while you're only paying for an hour of my time, you're really getting about 4 or 5 hours of my time in that meeting. And that's when the final cost of your plan will be determined. After that meeting, I usually take 2 or 3 weeks to actually draft everything, and then we will have a review meeting where we go over the plan to make sure it's what we discussed and it's still who you want to give things to and how you want the money to be distributed as far as milestones. And once that's approved, we have the signing and funding. So funding is when we retitle your assets, and you'll verify that your beneficiaries are named all to your accounts and things like that. Here are my three kind of top plans. We have a will-based plan, I have a trust-based plan, and then I have a plan for real estate investors that will also look into making sure your LLCs are structured properly. It'll go through your operational agreements and make sure that that is also in sync with either your will or your trust plan. I do have one higher plan. It's for family offices. I've only done that one once. It's about a $10,000 plan, but it lays out how you can be a family bank, basically. That's the dog. I knew she'd pop in at some point. I don't gatekeep on prices, so the will plan starts at about $1,500. The trust plan starts at $3,000. The real estate plan starts at about $6,000, and so that is for a single person. So there are add-ons for if you're married and whether or not we're doing what I call a sweetheart will, where they marry each other, or we're doing separate plans. So that's why we have that second design meeting to figure out that part of it. And the last thing I'll say on this is that it's just not me in this estate plan. It's a team effort. So I have CPAs and financial planners and insurance agents that we all work with. If you don't have your own, hopefully you, especially if you're a business owner, you already have some of these people in place that are helping you. So we all coordinate to make sure that your plan and your assets are growing the way you want them growing. And I know I have a couple of my partners on this call today, so I appreciate them for showing up as well. So yeah, as with anything, the best time to plan was yesterday. Today is the next best time. So here is how you get a hold of me. Take a screenshot of this information. You can call me directly at that 352 number. It is a Florida number. I started my firm in Florida, and so I'm keeping the number. And then my email, and then this QR code leads you directly to booking consult on my website. So thank you guys, and that is all I have for today. So I'm happy to answer questions for whatever time we have left.
Thank you so much for the presentation. It was very informative. I enjoyed it thoroughly. I do have a 21-year-old, so ours needs to include him having his own, sounds like.
He does, yeah.
For anyone who has questions, we have people on here from various states too, Dr. Shema, so it may
Sure.
not apply for Texas or Florida, but I would like to open the floor for those who have questions to come off mute.
Hey, Dr. Freeman, thank you so much for the information. I really enjoyed working with you. I have nothing but great things to speak about Dr. Freeman. But I wanted to know, how often are you going to be holding these seminars?
I think we're ramping up, right? I've been doing them about once a month, um, for my respective realtor partners. But I uh, am getting a sense that I need to turn this in more into an evergreen product. So at least twice a month. If my coach has her way, it'll be an every week type of deal. So we're working that out. But yeah, I will definitely be doing more of these for sure.
Okay. We'll keep in touch. I need to see about organizing some for you over here too.
Yes, and Erica is one of my partners, and she works for New York Life, and is Robin as well. So the two of them, I appreciate you guys for jumping on the call today. But
For
I can't speak enough
joining.
about how great it is to work with both Erica and Robin. So thank you.
Do you have a representative or office in Arkansas?
I don't off the top of my head, but I'm happy to go into my archive and find someone for you. What part of Arkansas are you in?
I'm in Pine Bluff, Arkansas.
Okay. Yeah, I do group coaching and individual coaching with a couple of different organizations. So we have a long directory that I can look into for you.
Is it true that there are some situations to where if you have a trust, it still has to go to probate?
Yes, that is something that could happen. Again, the funding part of the trust is the most important. And when I talk about funding, I'm meaning titling all of the assets. So if you have property in other states, that were never properly titled into the trust, and you may still need to probate that, and that'll be probated in the state that it's in. So anything that is, if you have a bank account for some reason that was missed in the titling process, that will still need to be probated. That's one of the things I'm dealing with my mom. She had one retirement check that went to a bank, and I had already closed that bank account, and so then it went to the state of Florida, and I'm trying to decide whether or not the cost of opening probate will offset that $1,300, right? So those are the decisions that you have to make. What else?
Anyone else have any questions or experiences that they've encountered that they'd like to share?
Yes, Monique, I can get you a copy of the slides.
I have a question. Do you help also with families who need to go through the probate process on getting land that like grandparents didn't properly do the paperwork?
Yes, ma'am. Airship affidavits are probably the easiest way to do that, but that's definitely a conversation that we can have about. I have a family in Houston that I'm helping do that very thing. They had some oil leases tied to the land, and it started off as 50 acres, and now we're down to 25 acres, and we're trying to figure out who owns what, and that sort of thing. So yes, ma'am, I can actually do that.
Thank you.
My family has probably about 60 acres that my grandparents left the family, and they left the will, but their children did not know that they needed to have the will probated. So we have determined after talking with a lot of attorneys that there's basically nothing that we can do for the
Yeah,
property at this time except for keep it in the family.
yeah, and I'd say you probably need to decide something to do with it, because have had situations where investors will start to buy off the interest of the heirs. And so then you have this random stranger that also owns the property because nobody wants to deal with it. So it's a cautionary tale. Um, Make sure you're paying the taxes on it. A lot of the work that I get, as far as heirs property, is they're going into tax lien foreclosure. And that's when your investor will come in, they will pay that tax lien, and then start to give the family a little piece of something just to get them to sign over their portion of the deed. So I would encourage your family to have the hard conversations and decide to do something with it. if nothing else, create a family trust. So there's one person that's ultimately managing the property, right? Um, and then you don't need all 20 people to sign off on everything all the time. But if you want to have that conversation, feel free to reach out to me as well.
Okay, but my grandparents' wish was for it to never be sold and to stay in the family, and anybody can use it
Yep.
that would like to. And that's basically what we're doing. Someone
Perfect.
goes to the property all the time. I pay the taxes on the property. We pay the water bill. So it's being maintained. Somebody is there. It's visibly there.
Perfect. Yeah.
But we just don't have a will in
The thing you
place.
don't want to do is abandon the property, right?
No,
Because
that's not
then
happening.
it's
No.
susceptible to a lot of different predators at that point.
We keep it cut, keep it cleaned, and so we
Mm,
are visible on the property. It's just that we don't
perfect.
have a will anymore.
Let me see.
I have a quick question for you, Dr. Shema.
Sure.
If someone has a will in place and they've been instructed not to do a trust, do you know why that might be, that a will covers everything?
Um, if they have a small estate, I didn't really get into like the types of different probate that you can go through.
Mm-hmm.
But yeah, there are small estates and minimum in a title that they only have the homestead property that they're concerned about. So there are plenty of more opportunity for a will to be the only thing that you need. It's always up for a discussion. But yeah, there are definitely circumstances where a will get it done.
Hi, Dr. Shema. I want to reach out to you because I did pay someone to establish a trust for me. It says it's a business trust, and I have my children listed as the beneficiaries. I do want to set up a will as well for my children, but I want to
Okay.
see if this was set up correctly. Um,
Yep, I can do a document review for you.
Thank you. I'll reach out to you. Thank you.
Perfect. Happy to help.
Dr. Freeman, is that appointment, because we need to review minds, but is
Yes,
that
ma'am.
appointment a consultation or is it a different type of appointment that I just need to
It's a
schedule?
different type of appointment. I always start with the discovery so I can see what you're trying to do, right? And then we determine what kind of appointment you need after that. So
Okay,
I
so
have
just schedule the discovery
just
appointment
discovered, just yeah, schedule the discovery and then we'll go from there.
and then just drop off all of my stuff to you. Here you go.
Pretty much,
Okay,
pretty much.
perfect. Thank you.
Thankfully, I have AI to help with some of that now, but a lot of it, the hearing that I have next week, the wife's answer is about that thick, and so it's just me sitting there reading 100 pages of documents. So yeah, I mean, you'll pay for that time at 275 an hour, but
Does anyone else have any questions? I hope y'all found this to be a breath of fresh air, just some confirmations and some encouragement to get some things done and get things in place. And I'd like to actually thank Monique for recommending this training. So she recommended it maybe about 6 weeks or so ago. And I asked Dr. Shima right away, and she agreed. So I thank you so much for your time, and I hope this has been a blessing to everyone who's been a part. And if there's anything else that you all would like to hear more about or training on, please share that in the chat or reach out to us so that we can set that up. Our goal is to add value to each one that we encounter. So we thank you all so much. Family, friends, business partners, everybody, thank y'all so much. Dr. Shima, you
thank you
have
guys.
final words, sweet lady?
No, I just thank you for your time. I hope you learned something today. This is truly my heart and my passion is for this work, and so I hope that that comes through because I really want to. This is my ministry. This is how I serve people. So thank
Absolutely.
you guys.
I have one quick question for you. Do you have a Google review link?
I don't. I'm so bad at this, but I'm
Okay.
working on it. I finally have an Instagram for the law firm. We've been going back and forth with Google, trying to get it set up since we are virtual.
Oh,
They make you jump through a few more hoops, but it's coming.
all right, super. Well, thank you all so much. Let's see, when is the next one? We will definitely let you know, Miss Patricia, and if you have anything specific you'd like to hear about with wealth building or real estate, let us know and we'll make it happen for you. All right. Y'all have an amazing day. Thank y'all so much.
Thank you, guys.
Thank
Bye-bye,
you.
y'all.
Thank you.
Bye.
Bye, Tamika. Nice
Bye-bye.
seeing you
Thank
again.
you.
Good to see
Thank
you.
you.
Mhm.